George Washington is pissed, and here's the latest in 2A news. Rare breed forced reset triggers, or FRTs, are
back on the menu, boys!
Well, at least in part. Let me explain. Late last week, the DOJ announced a settlement between itself and Rare Breed Triggers. In its press release, the DOJ stated, in accordance with President Trump's executive order protecting Second Amendment rights, as well as the Attorney General's Second Amendment Enforcement Task Force, the Department of Justice announced the settlement of litigation. That sounds really positive, right? And this is seemingly a win. But what did the parties actually agree to? Well, the parties agreed to dismiss 3 pending lawsuits with prejudice, meaning that those lawsuits can't be refiled by the same parties for the same thing against the same people. You sensing a theme here? Anyway, the government has agreed to the extent practicable to return all FRTs that were seized or voluntarily surrendered. If the DOJ currently has your property because you surrendered it like a little you must submit your request to have it returned to you by September 30th, 2025, consistent with the instructions on ATF's website. Now, I tried to do your homework quickly for you, and while it appears ATF has not updated its site yet, and they may not because, you know, it's the government and they never do anything quickly, there is a page from earlier in the year that directs people to email frt.return@atf.gov if you're an affected party, or a little. Of course, FRTs that were evidence in criminal investigations, prosecutions, or subject to forfeiture are excluded from return. However, and here's an interesting one, Rare Breed Triggers has agreed that it will not develop or design FRTs for use in any handgun. And the agreement specifies a handgun is to mean a firearm whose magazine loads into the trigger grip. Into the trigger grip. You know, the trigger grip thing. Thing that goes up.
That's a new term.
Yeah, new term. We're making up stuff. I didn't make it up. They did. They also agreed they're not going to market, advertise, or encourage individuals to put FRTs in handguns. The choice to exclude FRTs for handguns is likely because, in the government's mind anyway, there's no difference between an FRT for a handgun and, say, a Glock switch. On top of that, Rare Breed has agreed to take all reasonable efforts to engage in patent enforcement against any person or company that manufactures, sells, or distributes FRTs during the life of their patent. One would have to wonder if this ices out competition in the marketplace. It certainly seems that that would be a natural outcome. However, the point of obtaining a patent is to protect your intellectual property, and if you don't defend it, it's meaningless anyway. Notably, the government agrees to consider filing statements in support of Rare Breed's defense of its patents, detailing the public interest to be served by injunctions should Rare Breed actually bring one of these lawsuits in the future. So, put another way, Rare Breed gets the government's help. This one's new to me. Can't say I've seen the government offering assistance to private companies to keep competition out of the marketplace before, but hey, I don't know everything. That's why you're watching me, because I do know everything, because I'm a lawyer. Trust me. This is bad ad-libbing. So put simply, FRTs made by Rare Breed will be back in the marketplace and legal to possess and transfer. If one was confiscated or voluntarily surrendered, there is a mechanism to have it returned. All of those, very good things. However, the settlement agreement's terms about enforcing the patent appears to prevent other manufacturers from moving into the space, at least if the function of their product is similar to the FRT. On top of that, it seems that the government has concerns about FRTs being developed for handguns and may, in the future, take the position that those are machine guns. Time's going to tell on that point. While this is a win, in part, there are a few things up in the air that leaves a little uncertainty and room for future enforcement. I want to know what you guys think about this. Is it a win? Is it a problem? Is it a hot dog, a sandwich? Is cereal soup? These are the questions I need answered. Head on down to the comments and let your opinions be heard. Welcome back to the Big 2A, the show where we bring you all the top Second Amendment stories. I'm your host, Adam Kraut, and yes, soup is cereal. Also, if you're new around here, I would really appreciate it if you hit that subscribe button because it helps us more than you know. And we actually have a really good time making this for you, so it'd be great to see you again next time. Come back. There's more. Let's get into some more 2A news. You've probably been aware of a battle that's been brewing in the House for the past week or so as it relates to the Hearing Protection Act, also known as the HPA. The social medias have been on fire with commentary about this issue, and I agree, it's pretty important. While the HPA was introduced as a bill in both the House and the Senate, the current debate that's raging has little to do with the traditional manner in which a bill is passed. Currently, the House is working on a budget bill through a process known as reconciliation. This is important because the way in which a bill passes through reconciliation is different than your standard legislation. To begin, reconciliation is a special legislative process that allows certain revenue-related items to be passed with a simple majority in the Senate. This bypasses the usual 60-vote threshold to end debate on a bill and bring it to a vote. Notably, reconciliation is used for tax spending and other budgetary-related matters. On top of that, it can be used to enact bills without broad bipartisan support. So, something dealing with, I don't know, silencers. Seems simple enough so far, right? Well, let's throw a wrench in there and shed some light on the current shenanigans that are happening in the House. Several groups have been lobbying for the inclusion of the HPA in the reconciliation process, and while the House could put it in there in its entirety, the Senate's Byrd Rule, named after Senator Byrd, poses a potential problem.
There's no such thing as Byrd law.
Yes, there is!
The Byrd Rule prohibits the inclusion of extraneous measures in reconciliation, to include things like measures with no budgetary effect, or measures that produce a budgetary effect that is merely incidental to a non-budgetary policy change. Point being, if the proposed language is seen as outside of the budgetary scope, it can be thrown out by the Senate parliamentarian, which brings us back to our current predicament. As it stands when this was being filmed, the bill would remove the $200 tax from silencers, but they would still remain part of the NFA, meaning you'd still have to do all the paperwork and the registration process that goes along with it.
Oh, hey, it's John. Guess what? Since we filmed this, things have changed, unsurprisingly. Turns out that last night, the House passed that reconciliation bill with the language in Section 2 of the HPA included. That means, as wild as it might sound, the House is moving forward with removing suppressors from the NFA. That said, we still need to see what the Senate does and if they will mess with the language, but this is a very big step forward for us. Now back to Adam.
The language at issue in the HPA deals with removing silencers from the NFA. However, including all of that language could potentially spell disaster for any modification of the NFA through reconciliation, thanks to, well, you guessed it, the Byrd Rule. On top of that, since we're dealing with politicians, there's other issues at play as well. There is one more opportunity in the Rules Committee for this to be amended to add language to remove silencers from the NFA before the bill is sent to the Senate for consideration. From there, it's anyone's guess as to whether the language will remain or be tossed. And if it goes over without it, would the Senate add it? Remember, this situation is extremely fluid and may have already changed between us filming this and you seeing it. We'll have an update once the dust settles. Next up this week, Montana's governor has signed a bill banning local governmental units from enacting extreme risk protection orders, better known as red flag laws. Additionally, the new law prohibits these local governments from accepting grants or other sources of funding for the purposes of aiding in the adoption, implementation, or enforcement of an extreme risk protection order. And if you remember, that was a tactic the Biden administration wanted to leverage to get more municipalities to adopt these laws. The law gets better. Anytime a local government violates the new law, it's subject to a civil penalty of up to $10,000 payable to the state's general fund. You guys think cities in Montana are going to adopt these laws anyway? I mean, there's some pretty liberal places in Montana. I'm looking at you, Missoula. You can thank the Duttons for that. Moving on, Governor Stitt of Oklahoma, that's a state you never hear mentioned, signed House Bill 2818 into law last week, allowing Oklahomans, that's the word, isn't it? Well, to stand their ground even more. That's right, it's no longer a crime in Oklahoma to point your gun at someone while acting in self-defense or in defense of your private property. The bill added clarity to the existing stand your ground law in addition to expanding its protections to private property. So, get off my lawn. But in all seriousness, the new law does not allow you to brandish or point a firearm at anyone for the purposes of threatening them or discharging the firearm with any malice or for any purpose of injuring, either through physical injury or mental or emotional intimidation, or get this, for the purposes of whimsy, humor, pranks, or in anger or otherwise. Oklahoma, so whimsical. So, put simply, Oklahoma has clarified its stand your ground law, and that's good news for gun rights.